Welcome to the Court of History. I'm Sean Wilentz, Princeton historian, here with Sidney Blumenthal, a reporter extraordinaire and historian extraordinaire. We're here to talk about a piece that we wrote and published in Rolling Stone just a little while ago on the subject of originalism, the judicial ideology that in effect rules the country these days. Something that people don't all know about, understand quite. Even scholars don't quite fully understand it. We wrote this piece built on things that we've been working on for a long time now, more than a year, about the character of the Supreme Court in particular, but also about the broader intellectual justifications for what is in effect a right-wing assault on the Constitution. And the idea, the ideology, the fig leaf for this is a doctrine called originalism. And Sidney and I wanted to try to expose what exactly it stands for, its fraudulent use of history, which is something that means a great deal to us in particular, but also, the ways in which, what its history actually is, going back to the segregationist effort to roll back Brown v. Board of Education in 1954. It goes to the heart of the modern civil rights movement, but we'll talk about that in due course.
Well, Sean, this is how we began the Court of History. We began with our conversation about originalism.
Right.
And hardly anyone really understood that this is the ideology, and it is an ideology, a doctrine, at the bottom of the most damaging Supreme Court decisions over the last generation, used to justify predetermined results. But the doctrine is essential to it. And that's why we started our group, to try and debunk it and bring authority on history and the law to this. And yet this is a reigning ideology. It's so we wrote this article in Rolling Stone that that is sort of a basic short course in this. And if you really want to know what originalism is and what it's done and how to get to the bottom of it, you should read this Rolling Stone piece.
So why don't we just lay out exactly in a very brief way what is originalism and what does it stand for? What is the doctrine that we're talking about?
So people who use originalism, which also goes by other names and has corollary doctrines like textualism and history and tradition, claims that they are like in a seance, divining the intent, the original intent of the founders and framers, which they can then use in a narrow way to cite to justify the rulings of courts and their decisions. And what this does is eliminate the traditional law, actually, which had been thought of as real conservatism, going all the way back to Blackstone, all of Anglo-American jurisprudence and precedent, common law, the idea of the living Constitution, which, by the way, was both Jefferson and Lincoln's idea, and they wrote about it, and instead impose this, insist that everything be fitted to this Procrustean bed of originalism. And that may all sound abstract, but the consequences have been dire, haven't they?
Oh, they've been devastating. I mean, it's not as if normal jurisprudence, Anglo-American jurisprudence going back centuries, didn't take into account, or American jurists didn't take into account the Constitution. I mean, that was always important. The point is, you were not imprisoned, or you didn't use the Constitution as the basis for justifying your own very narrow reading of what the Constitution might be about. Without any regard to precedent, without regard to stare decisis, regard to nothing. But yes, I mean, if you go through the decisions, the big decisions that have been made over the years, originalism has become a kind of shell game, really, to fake out the public, to fake out other jurists, to make it sound as if this is something, original sounds somehow authoritative, when in fact it's simply something that's being made up with bad history to back it up. to
Well, let's
justify
talk about what
any death.
let's just cite some of the consequences that have been
Well,
dependent
yeah, I
on
mean,
originalism for decisions.
look at Dobbs. I mean, the Dobbs decision was one where bad history was brought to bear.
That's
Um,
abortion rights.
that's abortion rights. Well, we have it in the article. I mean, what exactly? It was the Alito decision, wasn't it, that was so particularly egregious in that regard?
Well, that's the Harris gun decision, and in which he claimed that uh, it wasn't limited to the text, actually, of the amendment to militias, but that it was a general right to carry guns.
But wasn't there something about what states had had eliminated abortion rights at a certain point and so forth? I mean, there was a decision that was made that was completely historically insane, as I recall.
Yeah, well, the Dobbs decision cited medieval law as,
Right.
as originalism, which is not, medieval European law. Obviously,
Right.
there's no medieval American law. So, but it goes from abortion to voting rights, gun control, environmental protection, and then now the big one, the so-called administrative state, by
Right.
which they mean the United States government as it's been created to promote the general welfare over
Right.
time,
Right.
um, built up by legislation and constitutional amendments, which they will all want to overthrow, interestingly, into something they call the unitary executive. And now they're worried a lot about it because Trump's there.
Yeah, right. Right. But look,
And
but there is a history to all of this, right? I mean, this is nothing that came out of. It's a brief history. It doesn't go back to the framers, that's for sure. But it does go back to the 1950s. And we can draw, as we do in the piece, we draw the line between the resistance to Brown v. Board of Ed in 1954, right up through Robert Bork, and then right up to the present. This is a line of argument that's
yeah, talk a little bit
basically
about the opposition to Brown. It's
yeah. I mean,
1954, and the Supreme
1954.
Court has issued a ruling, Brown v. Board of Education, declaring segregation in public schools to be unconstitutional. And then what happens?
Massive resistance. Suppose that was the term that was, ascribed to it. But there was an argument made by prominent segregationists, including James J. Kilpatrick, someone we kind of know about from the old days.
Well, he was an editorial writer for the Chief Richmond newspaper in
Right.
Virginia when it staged massive resistance and for years shut down the public schools rather than follow the law and integrate. But
Correct.
and then there was, of
Virginia,
course,
Maryland.
William F. Buckley's National Review, which was a prominent supporter of segregation.
And in all of these cases, they said that they had to sort of expunge the racist elements of this, right? They weren't going to, go down that road. The road they chose to go on was that they could go back and see what the Constitution originally said about all of these things, which, of course, would preclude the Civil War, would preclude a lot of things that had happened since 1787. But they were trying to wind back the clock. I think Kilpatrick actually said something like that we have to go back and wind back the clock if we're going to take the law seriously. This is all a way to evade or to try to traduce, a way to justify massive resistance, actually, on these grounds. But it was the germ of what we now know as originalism, which is to say that we're going to be able to find out what the Constitution really said.
And then after that initial reaction to Brown, in which they invoke words like intent construct, and invoked states' rights in an unreconstructed notion going back to John C. Calhoun, then enter Robert Bork.
Yes, well, Robert Bork would be the Solicitor General under Richard Nixon, the man who tried to undo the Saturday Night or did the Saturday Night Massacre.
Yeah, he
but before
appointed
that,
the Attorney General after two previous people refused to fire Archibald Cox as special prosecutor in Watergate, and Bork was willing to do the dirty deed.
That's right. But before that, he was a professor of law, and he'd written in the Yale Law Journal actually a piece that kind of updated and expanded the idea that had come around since 1954, the idea that original intention of the Constitution ought to be the measure, the standard by which judges ought to rule. They should take out their own personal ideas. They should take out anything else but what the Constitution actually said, what the framers actually meant. That was a very important article that came out in 1971. Bork himself, actually, fast forward, was going to be named to the Supreme Court by Ronald Reagan in 1987, I believe.
That's right.
And was rejected for being too extreme, and that's really the case in which we see the beginnings of, or the appointment, where we see the beginnings of the vicious kinds of battles over judicial appointments that we've seen ever since. While Bork was rejected, his ideas were becoming much more pervasive.
So what happens in the Reagan administration doesn't give this up. They promote it.
No, quite the opposite. I mean, in 1985, Attorney General Edwin Meese gave a speech, in fact, in which he basically laid out the idea of Borkian originalism as the standard by which the administration was going to go about understanding or pushing for judicial rulings that they liked. Meese was going to be disgraced not too far down the road himself over another whole scandal. But nevertheless, that speech gave the signal that originalism was now the official judicial doctrine, not just of the Nixon administration, but of the conservative movement as a whole. And the Reagan administration pushed it very, very hard. They didn't get Bork, but the idea, which was going to last for much longer than Robert Bork's article was going to do, really became very, very, what should we say, influential.
Then Reagan appointed somebody much more effective than Bork, much less feckless.
Actually, he was before Bork.
Originalism. Antonin Scalia appointed the Supreme Court in 1986, and he became the standard bearer of originalism.
Yeah, Scalia, who was a very different kind of character than Bork, and he got through before Bork was rejected. Scalia gets through. Is it unanimous or virtually unanimous in the Senate?
Yeah, he's a genial personality.
Exactly.
He likes to eat. He likes to take Ruth Bader Ginsburg out to dinner.
Yeah, and he was a Brooklyn boy, and he knew how to talk like a normal person, and he wasn't, condescending, but he was as you say, the tribune, the great carrier of the idea of originalism, which he was later eventually going to show his true colors in the notorious case of Bush v. Gore in 2000, in which he manipulated the 14th Amendment in such a way as to hand the election under supposed equal protection doctrine, completely messing it up, and in a decision that he later described, as we say in Brooklyn, he said, as a piece of shit.
Yes. Well, we won't censor that. That appears in a biography of Sandra Day O'Connor by the historian and journalist Evan Thomas. And it's very clearly sourced. But there's another actor who comes into this, and another organization to promote originalism. And without this, originalism is not doesn't become as powerful as it would have. And that is the Federalist Society, which began as a student study group on the right of conservatives at law schools and gets taken over. Enter Leonard Leo, who's a kind of political octopus, who creates, through his, a host of political action committees, raises billions of dollars in a slush fund to deny Democrats promotion to the federal bench and to promote Republicans and engage in electioneering and create a vast, as the communists used to say, transmission belt of grooming people in their political operation as lawyers for the federal bench and federal appointments.
Right.
And he's using all of his money in this way. And originalism, which is a newly minted concept, becomes the intellectual justification for this political movement.
Yeah, I mean, it becomes a creed, practically a dogma, and you're not going to get anywhere inside this. You're not going to enter the transmission belt unless you pledge fealty to originalism, and it actually gets to be taught in the law schools. It's not simply something that people pick up on the side or go to a Federalist Society meeting and pick up on. It has actually pervaded the law schools themselves as a what we call it, a justified, a genuine judicial doctrine. It's not a genuine judicial doctrine. It's a political doctrine with judicial or historical trappings. But people have been well schooled in this, and it's now, attained a degree of legitimacy, which would have been unimaginable, say, in the early 80s. But over the last 40 years, it's really taken over.
Yeah. Well, let's just, run very quickly through some of these decisions. There's Dobbs, of course, where Sam Alito, Justice Samuel Alito, claims that 28 out of 37 states,
yeah, that was the point I was trying to make earlier,
banned abortion throughout pregnancy at the time of the ratification of the 14th Amendment, and that was false.
That's wrong.
It's just, I'm sorry, but you failed your history class. But that doesn't matter. That becomes the originalist holy grail. And then we get Clarence Thomas in New York State Rifle and Pistol Association versus Bruin, known as the Bruin decision, strikes down a New York law requiring people to obtain an unrestricted license to carry a concealed firearm. And he dismisses all of the amicus briefs from real historians and instead cites English peasants in the 1500s carrying guns who are highwaymen. And that's the originalist precedent.
Yeah. This is kind of originalism on, psychedelic originalism or,
No, we haven't reached the level of psychedelic originalism yet.
Okay.
All right, that's 303 Creative LLC versus Alanus. That is.
Tell us about that one.
Elon Musk could not take enough drugs to understand this case.
Right.
So this is the ultimate in originalism because it is the case ruled on the Supreme Court, creates an originalist past to justify discriminating against gays on a religious basis for a cake maker not to make a wedding cake for gays in Colorado. Here's the problem with this originalism and what's consistent with it. The case is fabricated that the court rules on and becomes the basis now for law. There never was such a request for such a cake. There's no one who asked for it. And the designer of the cake had been put up by a right-wing group, one of those downstream from Leonard Leo's, money chains. And so the ruling not only asserts false history about religious speech, and separation of church and state,
and that's important. I mean, we have to take that into account. But
let's go into Jefferson and Madison for a little bit. But not only that, there is no reality to it. It's not even a reality TV show, which is fictional. There's no reality to it, and yet it becomes the law of the land. And that, to me, is they have finally reached the highest stage of originalism.
So what do we, apart from exposing it, what do we do about all of this? I mean, how do we fight back against all of this stuff? I mean, just exposing it, embarrassing them, maybe that's one step forward. But
there are those, and I'd like to get your opinion, Sean. There are those who say we should cite better history and be originalists ourselves and cite that against the
Yeah.
originalists. What do you
Yeah.
think of that?
Well, I think that's playing on their turf, if you will. I mean, the whole idea of there being a historical basis in the way that they say is, to me, undoes Anglo-American jurisprudence. It's just playing their game, and they're going to win that game if you're playing on their turf. So I don't think that's the way to go about it. Now, there are grounds for using the Constitution wisely, for using the Constitution historically correctly. It's not as if that's not something that we should do. I think, but I think that to cast it as a kind of counter originalism, that just seeds the falseness of their premises. Is just not goes unchallenged, and we can't allow that. We have to get back to what has long been the basis for making these kinds of judicial decisions, which involves the Constitution, but not in this very, very crazy, narrow way. Does that
Yeah,
sound? I mean.
well, in some ways, this is a parallel universe to what they claim is the woke ideology,
Mm,
which is they say is intolerant of liberalism and imposes ideological strictures and so on, which is has a point, but also is a good self-description of originalism.
right. Well, and
And
also, yeah, go ahead.
go ahead.
No, I'm just saying it goes back to the idea of judicial activism. That was the word that was always used, going all the way back to Brown. The idea was that liberals were judicial activists who were bending the meaning of the Constitution, substituting their own political preferences, et cetera, et cetera, et cetera. This is this is a complete, what should we say, inversion or projection, because there's nothing more activist than what the right wing has been doing on the court for the last 20, 30 years, which
Yeah,
is exactly imposing their own ideas on the Constitution.
yeah, a good deal of what the right does is what the Freudians call projection.
Yes.
It's and one way of, for example, simple way to begin to understand Trump is to read his accusations, and then you may know what he's doing. So
Exactly.
it's
Exactly.
projection, but
But it also goes to the use of history, right? I mean, history is as part of this imposition of values. I mean, they cloak themselves with a historical authority. It's as if the liberals don't really like the Constitution very much. They're just going to bend it the way they want to. But they then cloak it we give it a historical authority, which is totally bogus, and that has to be understood as well.
yeah, they ignore history in order to invoke history.
Correct.
So they ignore the practical sense of the framers while they're conducting these seances, hearing the true voices from the beyond, which
Yeah.
table rappings and it's like ghost photography from the 19th century. But Madison and Jefferson debunked all this in the beginning.
Exactly. That's what I wanted to get to.
Yeah.
I
So
mean, they said quite explicitly that that what we're talking about here in the Constitutional Convention in 1787, et cetera, should not be writ like scripture down through the ages. This is nothing that they intended to do. Quite
yeah,
the opposite.
I have a quote from M. Madison that we put in the article
Yeah,
from the Constitutional Convention. And Madison says, in framing a system which we wish to last for ages, we should not lose sight of the changes that ages will produce. And then later, when he's a member of the House of Representatives, he says, whatever veneration must be entertained for the body of men who formed our Constitution, the sense of that body could never be regarded as the oracular guide in expounding the Constitution. It's a direct refutation of the originalist premise.
exactly. So, just to wrap up, in some ways, what we have to do is vindicate James Madison and vindicate the framers by exposing this originalism as traducing what they actually intended. This is not originalism against originalism. This is just plain history. We're not trying to go back and find the original intention. Just look what the Constitution was all about, as they said so, and then proceed on that basis.
Yeah. Well, we lay it all out in a short course in this Rolling Stone article, and we're going to continue to raise these issues and go through them on the Court of History.
So we hope you'll be able to read the piece in Rolling Stone. It's online right now, and we'll look forward to seeing you the next time on the Court of History.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.